had maps. And he just came up here and told you about how dinky little what? And my next one is a map. Holy shit. I'm going back to flip charts. And the next one is a map. I am a dinosaur. But the last one, and this was really going to be great, is this timetable. What do they call that? The schedule of from the transit department for when trains came to and from, and the last train that ran from Damon Station. So you've now seen my entire pictorial presentation. The case. This case has a feature to it. Anybody see my notes? Can you hear me? I am a poster child for ADD. Tony Cueto came by last night. Everybody says I obsess about my stuff, and it's true. And so he came by to drink some whiskey with me last night about 11 o'clock while I was obsessing to calm me down a little bit. And so I decided that I'm going to come to a part of this closing. You figured out about the three white men. You know about the witness who saw the three white men going from the scene of the crime, the first picture I had up there. You've seen, you figured out that the EMT and this incredible failure on the part of the Chicago police to chase those three white men, to track them down. I had a story that I was going to tell that I thought it fell in, and my three visitors said it was a crappy, hinky kind of story, and I was going to tell about, and this is a true story, when I was a kid, my dad, down here we call him Daddy, my daddy used to come home from work with these stories. I was about 10 years old, and it just got to be fun. They were little moron stories, we call them. And the little moron and his daddy went off fishing, and they had such a great day fishing, and they wanted to mark the spot so they could come back to it, so they put an X on the side of the boat. The little moron lost his baseball glove out in the yard. And it was nighttime, and he had to go play ball in the morning. And he's going all through the house looking for the baseball glove. And his daddy says, "Little moron, why are you looking in here?" And little moron says, "Because the light's better in here." And that was going to be a theme that I had all planned. See, I'm having to tell you about this great closing I had planned because I've changed it. I was going to talk about how the police officers, the Chicago Police Department, didn't chase the three white men because Morales and Otero, I was going to call him Judas Otero. I thought that had a nice ring. How they brought light. You could look in the wrong place. It was brighter, easier. You didn't have to go out in the yard in the dark to find the three white men. They told me that wouldn't work, so I didn't. You bring it. The thing that sets this case apart, and the reason that my presentation is brown shoes among tuxedos, is that this is a false confession case. And with all the people that got everything out of this case, and you got it all right, and you argued it, and I checked with my faculty members as they were, my fellow faculty members as they were screwing with me last night, they all said, yeah, this is what they argued about. And then we finally came to the decision that we really needed to focus on the false confession, because nobody really picked up on that as a theme in the course of their closing arguments or in the course of the presentation. I need Elmo now. I have done Elmo before, but I gotta find it. Latoya.
It's on the side of that?
All right,
It's
got it.
the other side. You gotta turn that side. I would know help about.
Oh, yeah, I forgot about that. One of my partners, been with me 10 years, was on staff here, and I hired her. And she does all this stuff for me, because she can figure it out, and I don't know about it. She's brilliant. She's like the staff we have now.
And she is not me.
I went yesterday afternoon, and Rick came and sort of set this up for me. And so we're going to play this out as when he did the cross-examination of the McMurray and talked about interrogation and interrogation techniques. I thought it was a great cross-examination. And that's when my Thursday afternoons when my wheels started clicking, saying I need to maybe turn this into a discussion of false confessions and how do you deal with it and how do you deal with it in a closing argument. Am I doing all right, Ed? Okay. He was one of my visitors. And so what I did, you're going to pretend that this is the chart that Rick put up. And I like to do that in a courtroom because I like flip charts and things. I write things down during the course of a trial. When a witness says something, or when we go down, we create a chart or something of that nature, I bring it back in closing argument. And so I had to write it a little bigger because from the back I couldn't really read what Rick had written down. And so that's why that's a little bigger. And these are essentially the elements in any interrogation. If you take the Reed method or any of the other things in interrogation school, these are some of the elements or some version of these elements. So I'm setting the stage for what we're about to do. The Elmo, yesterday afternoon, I went to the law library upstairs because I haven't progressed beyond Xerox machines. I went up and photostated some pages from the charge book for Georgia. I'm familiar with these charges, so we're going to pretend these are Illinois charges. And these are important charges because every state, every jurisdiction has some pattern charges having to do with voluntariness of a confession. So when you have a voluntariness issue, and you've already had some, and you'll have more, you need to go look up the law and be ready to deal with it, because as you know, the jury is not going to know that the judge has already ruled that the jury can hear. You've already raised the voluntariness issue. And so the jury is not going to know that that issue has been passed on one time, and the jury is going to have the opportunity in judging the guilt of Lorenzo. And see, Bertie wore her Lorenzo shirt for me, and now she has to sit over there. But you need to focus on that. I'm going to get out of the lecture mode and I'm going to start doing closing argument on this issue. And so what I've done, it would be in a little different format if we were in a courtroom, and I'm going to put it on Elmo rather than have it on a flip chart. What the law is as it relates to voluntariness of confession. About there.
Yeah, that's fine.
Good. Our prosecutor is Mr. Hodges. Mr. Hodges is based, brought to you, a tape recorder. He says his case is strong because that tape recording is a confession produced in a police interview. Monday, when we opened this case, I said it was neither a confession and it was not an interview. It was an interview in the same sense that Katrina was a windy day in New Orleans. It was something totally different. It was an interrogation. Remember, my partner, Mr. Heyman, cross-examined Detective McMurray about what an interrogation is. The product of that interrogation was not a confession, it was a tape recording. We'll talk about what a confession is. Interviews are where you go apply for a job. Interviews are where the newspaper comes and gathers information. Normally wear suspenders. And gathers information to put something in the newspaper. Interrogations are what prisoners of war go through. Interrogations are what produce our great heroes on videotape confessing that war crimes. They bring out not truth. They bring out something not totally opposite truth. This was a tape recording of an interrogation of a 17-year-old boy. A boy with a learning disability who dropped out of the 9th grade special education because he couldn't read well. It was a tape recording produced through the elements of interrogation, as Mr. Kamen told us the other day. They broke him down. He wanted sleep. He was desperate for sleep. It was 7 o'clock in the morning. 11 hours had gone by, a little less before he first broke. And he would have confessed to sinking the Titanic, to anything, just make this end. He's not trained like our war heroes who break under a different kind of interrogation, but it's the same process. You, ladies and gentlemen, will decide whether Mr. Hodges is correct or I'm correct. You decide whether this is a confession, because you see, if it's not a confession, if it is what I have said it is, there is no case for the state. The state's case is the tape-recorded statement of a broken 17-year-old. In our state, and the judge, the court will charge you. I'm sorry, I'm not going to be able to read it all over with. In our state, there is law having to do with what a confession is or is not. Under our Constitution, federal, there is law about what a confession is and is not. Every state expresses it a little differently, but this is the way it's expressed in whatever state we're trying, in this case, Illinois. A statement that the defendant allegedly made. Well, Lorenzo made the statement. We're not saying that he didn't. Has been offered to you for your consideration, and before you may consider this as evidence for any purpose, you must answer the following. Before you consider it, before you weigh that 6 hours, 7 hours of interrogation that you endured on Tuesday, have to decide whether it was voluntary. You must consider the following, and I won't read to you all of the factors that the court would charge you, but I won't talk to you about the voluntariness. First, was the defendant warned of his or her constitutional rights, and did the defendant understand and knowingly give up such rights? And you remember when the detective was cross-examined by Mr. Kamen, the question came up, one of the elements of interrogation was to give a Miranda warning, not one of the first elements. Unfortunately, if they did it that way, these statements would be very different. The burden of proof, and I've highlighted the portions of this charge that are important in this case. The burden of proof is upon the state to establish the warnings of all rights mentioned, establish that they were given, establish that they were understood, and knowingly given up by the defendant. As for an adult, Lorenzo was 17. He hadn't crossed that line. Our 17-year-old learning disabled, special education dropout. In considering whether a statement by a juvenile defendant, that is Lorenzo, whether it was knowingly and whether there was a knowing and intelligent waiver of his constitutional rights, you are to consider the totality of the circumstances. Factors you may consider to determine whether the defendant has made a knowing and intelligent waiver include, but are not limited to, the age of the defendant, the education of the defendant, knowledge of the defendant as to the substance of the charge and nature of his or her right to consult an attorney, whether the defendant was allowed to consult with relatives or an attorney. Remember, Lorenzo is in this country, in this world, alone. His father was deported, his mother passed away. He's a citizen, he's one of us, but he's alone in the world. There was no family for Lorenzo to call. Whether the defendant was interrogated before or after formal charges had been filed. Well, Lorenzo didn't even know when this began what the potential charges were. He'd been in custody when they started interrogating him in the holding cell by himself for 3 hours before they came to get him. The reason he was in the holding cell alone for 3 hours was to impress upon him that he did not control his current environment. The methods used in questioning, and we'll go through those as we go through the statement. Whether the defendant refused to voluntarily give statements on prior occasions, and this was the first occasion, I guess we could say, or was it? If there are hour breaks in between when he's not cooperating because he's not admitting to what they want him to admit to, and then they come back and restart the process, is that a time when he refused the interrogation on a prior occasion? I submit to you that it is. Whether the defendant withdrew or denied making the statement at a later date. We don't contest that this statement was what you heard. In fact, we urge you to consider that it was exactly what you heard. In fact, you can ask, if you want to hear it again, parts of it or all of it, you can ask the court during your deliberations, and you may well want to do that. This is an important case. That will take time. But at the time that you heard that tape recording for the first time, you hadn't considered or been asked to consider these factors. And here's the key. Voluntariness. The other issue you must determine, address, is whether the defendant's statement was voluntary. That is, freely and willingly given. And remember, you've got to consider this before you can consider the statement. This is really not. You've got to consider the tape before you make this final determination. But before you consider the tape as evidence of guilt or innocence, you've got to consider whether it was voluntary. And then we define in Georgia, Illinois, voluntariness. To be voluntary, a statement must be freely and willingly given, and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced, let me go slowly through this sentence. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. If it is induced by the slightest hope of benefit or the remotest fear of injury, it is not voluntary. And if it is not voluntary, you may not consider it. And in this case, that's where the state has put all its marks. That's where the state has asked you to determine whether Lorenzo is a murderer and robber. And finally, and we've talked about, or the court will talk to you about burden of proof generally, beyond a reasonable doubt. I won't address those standards right now, but we'll have a charge, an instruction on reasonable doubt and burden of proof, what that means. But in terms of the voluntariness of this statement, whether it is a confession or a tape recording of a broken 17-year-old, the burden of proof is upon the state to establish that the statement was voluntary and was freely and willingly made. If the state does not prove beyond a reasonable doubt that this was a voluntary statement, not induced by the remotest fear of injury or the slightest hope of benefit, then you may not consider the statement. And under your oath, I know you won't, and there is no evidence. And you will be required, under your oath, to avoid the injustice of convicting. Now let's look at the statement to see how it fits under this standard. I'm going to step out of character now and suggest to you that if you were going to do this, you might play portions of the tape that I'm about to read to you, but we don't, in this problem, have the actual audio recording. So we're going to have to go a little more tediously through what was there. I'd suggest that you get your tape recorder, you play to this spot, play to that spot. Jurors will be writing down notes as we play into the definition. 7:52. On the 20th of August of last year, Lorenzo Benito was arrested. Set up by Jesus Otero, who immediately was looking for a reward. And he was put in a holding cell. Isolation, away from the world, not knowing, because you see he wasn't told when he was picked up and cuffed and slammed into the back of a squad car why they were doing it. You see, when they came to the table and said, "I need some ID," Lorenzo didn't know he had anything to fear. He didn't know why they were asking for ID, and so he produced an identification. That was voluntary. I am Lorenzo Benito. And that got him arrested for some reason that he didn't know at the time. So 3 hours in isolation, that's controlling the setting. That's saying to Lorenzo, they didn't have to wait 3 hours in a holding cell. They had planned this arrest for 7 days in some fashion or form. It was set up. He could have been interrogated immediately. They would have had control of the situation, but they had to impress upon him. This is our place. This is our turf. We control this situation because, you see, that's part of the standard protocol in this city for interrogation. Control the situation. Don't let this 17-year-old boy think he can get up and walk out. Don't let him think until later that there may be a way out of this situation. Three hours later, after he's slammed into the holding cell, and these times, you can mark them on the tape when you listen to them. Detective McMurray, big fellow, you saw him, and his partner, Detective Stinglitz, I don't know how to pronounce it, retrieve Lorenzo from the holding cell, and they take him to they call it the interview room. I call it the interrogation room. It's dark, it's white, it's cold. It has a table much smaller than the table where Lorenzo sits today. It has chairs much harder than the chairs in this courtroom. You saw the photographs of the interrogation room. They're controlling the set. But you know, there's a little relief to Lorenzo because they're just talking about his background, who he is. You know, I dropped out in 9th grade. I love baseball. My mama died. Gee, that's tough. I got no family. Gee, that's tough. 45 minutes of that. Building rapport. God, I was in an awful situation down in that holding cell, but now these guys seem to be fairly decent. Not sure why they want to talk to me. Maybe they think I saw something. But they're being nice to me. It's kind of a crappy room and it's cold, but they're being nice to me. And then they gave the Miranda warning. Now let me quote from you. 4 hours into this controlled situation. (23:55), that's military time. They put it down. That's 11:55. 5 minutes before midnight, and this 17-year-old boy is in this holding cell with two big officers and no one to talk to. We got some stuff we want to talk to you about, but first, you know, we have to read you your Miranda rights. It's a formality. Quote, it's a formality. It's a formality we have to go over. Let me get this over. Yeah, they read him his Miranda warnings. And if you listen closely to the tape, they told him he had a right to remain silent, he had a right to a lawyer, he had that anything he used would be used against him, anything he said, and that they would hire a lawyer for him. Why do I need a lawyer? I don't even know why I'm here. I'm not afraid of cops. Never done anything wrong. Why in the world would I need a lawyer? And then they say, we have information that you were involved in the killing of the banker up by the Art Museum on Michigan Avenue. And remember, Detective McMurray said, well, we're allowed to take liberties with the truth. That's police talk for lie. We're allowed to lie to you, you're not allowed to lie to us. We're allowed to make misrepresentations, but by God, you better say what we want you to say. And we're going to talk about not just saying what they want to say, but saying it how they want to say it. We've got a really, really strong case, Lorenzo. We like you. We don't think you're a cold-blooded killer. But we got this file on the table. That says you're the killer. Actually, we don't even need you to admit that you killed John Hussers. We just want to know why, because that's important to us to know why you did it. It sort of lets us know how to treat you. But we have you another liberty with truth. We have you on tape. You know, they had tapes all around the Art Museum. We got hair. It's your hair. We know it is, 100% sure, because we're going to have DNA. We just need to know why you would do this. Because if it's a cold-blooded killing, premeditated, it's one thing, but if it was something else, it's not. So it's kind of a back and forth. He says, I couldn't have done it. I was in Streeter working with my friend Luis Delgado on his house. Oh, okay, we'll check your alibi. Of course, they never checked his alibi. They didn't care about his alibi. They had this man where the light was shining. And they were going to get the statement they wanted because the light was better on him. But we'll check out your alibi. That's a little bit of building the rapport. As Mr. Kamen said, part of that control, building rapport, back and forth, make it tough, make it easier. I think it may be on TV, you've seen it as good cop, bad cop. It's a learned helplessness. It's a learned, and they teach it quickly to 17-year-old learning disabled children. 5 hours after the arrest, 1:05 in the morning. 5 hours of no friendly faces except for these two guys. We know you're not a cold-blooded killer. But we know that the gang people wanted you to do it, that you were forced to do it, and that does two things. They're still offering a little bit of rapport. They're offering an alternative to this terrible scene, but Lorenzo is still in disbelief that anyone would accuse him. I don't know how many times I can tell you, I didn't do this. I just want to go home. If you don't tell us your side, people will think you're a cold-blooded killer. I don't know nothing about this. If I knew, I would have told you so I can go home. 6 hours later, 6 hours after your arrest. What if I just remained silent? You said I could do that. For the rest of the time that y'all were talking, because y'all was not something to say in Chicago, I guess, but for the rest of the time that you're talking, I'll just remain silent, okay? Is that, you get to answer the question. On the question of whether it's a voluntary right, is that a refusal to talk further? Is that an invocation of Miranda rights when you decide whether this was a confession or a tape-recorded statement of a broken 17-year-old? When he says, I'll just remain silent, has he invoked his rights? Did they continue to interrogate? Is this now an involuntary statement from here out because of the law has said to you that? Tell you what, at 2:09 in the morning, I don't know how long Lorenzo had been up before he was arrested. Tell you what, leave me your number. If I hear anything, I'll let you know. Now, here's the slightest hope of benefit. We have to finish this up before you can go home. You do want to clear it up, don't you? You know, the implication is clear it up for us. You get to go home. Is that slight benefit? You, ladies and gentlemen, decide that based on the charge that you'll get from the court. Yeah, I want to clear it up. Like I told you, I wasn't there. I was in Streeter with Luis Delgado, working on his house. And the interrogation continues, and Lorenzo continues. I know nothing about this. You listen to his voice on the tape. You tell us, because you're allowed to use your everyday senses to read into voices, the power play, the feelings, the emotions. No one's going to believe that crap about Streeter, but I tell you what, we'll check on it. This is 6.5 hours after the arrest. McMurray has lost control. Lorenzo is not cooperating. He's not telling them what they want him to hear. I said that wrong. Not telling them what they want him to say. So they shut it down. They go back to square one. They shut it down for an hour of isolation, from 2:30 in the morning to 3:30 in the morning, alone, in the interrogation room, in the hard chair. No bathroom break at this point. No Coke, no candy bar. At least they gave him that when it started hours earlier. 3:30, 7.5 hours of controlling the situation. We checked. We called Streeter. No such person as Luis Delgado. You're lying to us, buddy. We know it. Well, of course, it's a lie. It's a liberty with the truth. They didn't call. I want to help you with this, but I can't if you stick to this story. Holding out slightest hope of benefit. Back to building rapport. Look, Lorenzo, I'm on your side. You need to know we've got a number of witnesses. Who? Can't be any witnesses. It didn't happen. Any witness you have is telling a lie. I think you had to do it, Lorenzo. I think you had no choice. I think the gang made you do it, posing an alternative. The question is, are you a cold-blooded killer, like Otero and Morales say? Or was it an accident? Which one was it? I would never kill anyone on purpose. So it was an accident. 5:30 in the morning, he cracks. Yeah, it was an accident. How did it happen? And this goes to the last element, finding corroboration. I was told I had to go downtown and rob someone. I was told. You see, he was already told that that's what he should say. They suggested that in the questioning. Can you tell me who told you? No, I can't tell you that. I'd get hurt. He bought into the gang. They might kill me. I was down for the robbery, but I did not intend to shoot anyone. What about selling rock? He denies it. They put the pressure on. Look, we know the truth. They're trying to make it match Morales' statement. They're finding corroboration. If he wasn't down there selling crack cocaine, then he didn't corroborate. The problem was that didn't corroborate with Otero. You've come this far, you can't go that halfway. Tell it, you have to tell it all. We're not here to get you in trouble for selling rock. Yeah, okay, all right, I was down there selling rock. What kind of gun? And see, they lost corroboration here. What kind of gun? Oh, it was a .22. No, Lorenzo, what kind of gun? You got to tell it all. It was a 9. It was a 9mm. No, Lorenzo, you got to tell us the truth. Why are you lying to us about that? Okay, it was a .32. They're happy. They move on. It was a .32. What'd you do with it? I threw it in the lake. Lorenzo, look. We'll find it in the lake. I mean, at that point, isn't Morales or isn't McMurray saying, I got a real problem with this statement because I know in my back of my mind he's just cooperating with me, and if I buy into he bought it threw it in the lake, we're going to have to go up there and find it. No, I threw it in the sewer. Where? I don't know. Well, that's okay. Won't be able to find that. What about the wallet, Lorenzo? How'd you take it? Well, I took it out of his back pocket. But if you are to believe Morales says that he told him he took it out of the front pocket. That's what 11 and a half hours of custody produces for a 17-year-old mentally challenged young man. You decide whether I'm taking way too much time. You decide whether it is voluntary. You decide whether it was induced by the remotest fear of harm or the slightest hope of benefit. If it was not, and I submit to you that it could not have been, then you don't consider that statement, and there is no evidence.